So here it is after a week of being sick. Here is your second video on prior written notice. Last time I walked you through the 7 things that legally have to be in the prior written notice. And the comments told me exactly what I suspected. A lot of you have never actually found that document because you've been told that the paper you get before your ARD meeting is your prior written notice. It's not. The paper you get before your ARD meeting is notice of the ARD. An invitation, federal law says that only has to tell you 4 things: the purpose of the meeting, the time, the place, and who's going to be there. And in Texas, you're supposed to get it at least 5 school days before the meeting unless you agree to a shorter time frame. That's why it's mostly check boxes. Annual review, check. Review of evaluation, check. Transition, check. Box, check. Box, check. That's it. You're not agreeing to anything the district is proposing. You're not consenting to services. You're not signing your child's IEP. You are saying whether or not you'll be at the meeting. So here's your homework. Get out your ARD paperwork from your last meeting. The whole stack, not just the cover page, not just the goals, not just the accommodations. Somewhere in there is a page actually titled Prior Written Notice. In most districts, it's usually in the back after the deliberations and the signature page. It's the page that nobody reads because by the time you get there, you're exhausted and it looks just like a boilerplate, but it's not. It's the document we went through last time. Those 7 required elements written out in paragraphs. Go read element 6 one more time, the other options the ARD committee considered and the reasons those options were rejected. Now, how can they hand you that after the meeting and still call it prior? Here's the answer. Prior doesn't mean prior to the meeting. It means prior to the district actually doing all the things. In Texas, it's at least 5 school days before they act on it. So getting your prior written notice in the packet after the ARD is perfectly legal. Read that Texas rule one more time though. 5 school days, unless the parent agrees to a shorter timeline. So somewhere in that meeting at the end, you may be asked to agree to a shorter time frame so the IEP can start right away. Sign that and your 5 days go away, which means you just agreed to shorten your review window on a document you have not read yet. Now that's not illegal, but I want you to see the trade-off you're making because no one's going to explain it to you on your way out the door. 2 things to hold on to. 1, signing that waiver is a choice. You are allowed to say, I'd like my 5 days. 2, agreeing to a shorter time frame does not excuse the district from giving you prior written notice